back to the Law and Crime Network. I'm Heather Hansen, and we are covering two compelling trials here tonight. All right, while Ms. Garcia looks at her papers, I want to bring in Eric Johnson again. Eric, we have transitioned cases here, and now we're looking at the McStay case. This woman is testifying to some of the financials, which has become such a big part of this case. Do you think that that's enough for the jury to accept some of the missing evidence that we've seen in this case thus far?
Well, I think the financial issues are going to work both ways. As the defense is trying to point to a third party, if they can put up enough cloudy material that they can show that there was financial situations going both ways with Mr. Merritt, as well as this third party in their business dealing with Mr. McStay, it may muddle the facts so much that the jury is unsure. I do think that if there's an informed jury, they're going to be looking at something a little bit more than the financials to tie them in, given that the state has such little evidence directly pointing them to the crime.
Yeah, I couldn't agree with you more. It's such an interesting case because they're so focused on this purported motive, and motive in and of itself isn't enough to establish what the prosecution needs to establish to overcome reasonable doubt. Do you think over the course of this very long trial, there has to be something else that sort of ties this together?
Well, I think the length of the trial and the amount of attention that the state is playing on the financial matters, hopefully they think that by spending so much time on it, the jury will focus in on that and hone in on what their theory is of a motive. Without that, I don't think that the state is going to be able to get a conviction on Mr. Merritt in this matter without bringing in, as you say, something else to tie it in. Yeah,
it's a fascinating case, and so many of us here at the Law and Crime Network have been wondering at where that sort of smoking gun might be. This particular witness has testified that some of the checks that she got from Merritt on the 8th, the signatures on those checks were different than the signatures on the checks that she got from Joseph. Now, that would be great evidence in a fraud case or some sort of a financial case, but in a murder case, how much does that impact a jury?
Well, the issue is what the state would be trying to show from that is that he was committing these forgeries because he knew that Mr. McStay was dead and was trying to take his money after the fact. But if he had the ability to do these things beforehand, as they say that they had these existing financial troubles, then that kind of decreases that the force of that evidence because he had the ability to do this before. So the fact that he's doing it after his death doesn't necessarily mean he had something to do with Mr. McStay's demise.
Yeah, I'm with you, Eric. This is going to be an interesting one to watch. Ladies and gentlemen, we're going to take a quick break, and when we come back, we'll go right back into that courtroom. All right, ladies and gentlemen, so poor Carmen Garcia is finally done with her examination. I want to bring Eric back in. Eric, when you have a witness like this one who is really no skin in the game, is it effective in front of the jury to be sort of aggressive in examination like some of these lawyers tended to be towards the end?
Well, I think it all depends on the witness's demeanor and how forthcoming they are with what the facts that you're trying to get up out of them. I mean, any witness, no matter what their interest is in the case, if they're not going in the direction that you want, you may have to treat them with hostility to try to get your point across. So depending on what the strategy of the attorneys were in this case, you know, that might be why they tried to go at her a little harder. But I don't think that they were going at her so hard as far as just trying to go back and forth with each other to go at one particular point.
Yeah, and that makes a really good point, Eric. Sometimes at the end of a witness's examination, it starts to get like almost like a tennis game where the two lawyers just want to end with the better point, and so they keep doing redirect, recross, redirect, recross. Do you think that the jury gets sick of that, or do you think that they enjoy the little bit of gamemanship there?
Well, I think they get sick of it, especially in a trial that's entering into its fourth week. I think at this particular point, they just want them to get to the point and move the case on. So a lot of back and forth that's not really advancing either position in this case may be looked disfavorably by the jury.
Yeah, I couldn't agree with you more. I think that especially in a case that's going on this long, at certain points, they feel as though, okay, we've got it. Let's move on to the next person. Now, they're taking their mid-morning break at this moment, and I want to talk to you a little bit about jurors and how they watch other people in the courtroom. We just saw the defendant on the camera on your screen there. Do you think that he's been told and counseled by his attorneys that he is constantly on stage when it comes to this jury?
Oh, well, they should have told him that before the jury was even selected, that, you know, as soon as the jury sees you, you should be engaging, you should be interested in your case, taking notes, making an attempt to make eye contact with each juror during the course of the trial to try to humanize yourself with them. You know, you don't want to stare or appear intimidating, especially in a case that describing a brutal death like we have here of 4 human beings. So you want to sit there, you want to be engaged, you want to smile, but you definitely want to pay attention, because if the jury feels that you're not paying attention and don't care about your case, neither will they.
Absolutely. I could not agree more. Okay, guys, we're going to take a quick break. When we come back, we will bring you back to one of these courtrooms or continue to discuss with Eric. Welcome back to the Law and Crime Network. Ladies and gentlemen, in the McStay case, they are now on their mid-morning break. So we want to show you a little bit of the testimony that we've heard thus far in this compelling case that's going to get confusing with the number of detectives that we've heard from different detective agencies. This particular piece is from Joseph Steers. He's from the San Bernardino Police Department. He's a detective there. So let's take a listen at his testimony that happened earlier this week.
To you as an initial investigator evaluating the state of the investigation when you saw that photograph?
That there were no towels inside the bathroom.
And is this the downstairs bathroom?
That's correct.
Exhibit number 100. Is that the upstairs bathroom?
Yes, the upstairs shared bathroom.
And what was significant about that photograph when you reviewed it?
Again, no towels.
Exhibit 660 in the top left. That is what?
That's the master bathroom, and there's one hook with no robe, and then a second hook with a bathroom on.
In the bottom left, exhibit number 53, what is that?
That's the downstairs bathroom toilet, where there's a decorative rug chamois on the toilet seat, and no matching floor rugs or any other type of matching set to it.
Did that cause you to look at the evidence that was recovered from the grave sites?
Yes.
Showing you exhibit number 297 as displayed. What was significant about that?
Looking at the fabric and the way it's depicted in the photograph, it appeared consistent with what would be either the bathrobe, if there's one missing from the hook, or from matching rug to the toilet seat cover.
Number 293, what was significant about that?
293 appeared to be a towel with the sunflower type print, consistent with a bath towel or beach towel, which I did not notice in any of the other photographs of the residents at the time of search warrant.
Now, the fabric material, fuzzy fabric material 297 and then the towel in 293, those were not the exclusive pieces of evidence taken from the grave that piqued your curiosity, was it?
No, they weren't.
There were other pieces of material found to your knowledge?
So, ladies and gentlemen, that was Joseph Steers, a detective, and we've heard from a lot of detectives in this case. Eric, I want to bring you back in on this. Any time that there are some missing pieces in a police or detective investigation, that sort of opens up a big space for the defense to walk right through on their way to victory, doesn't it?
Yes, it does. The absence of evidence, as well as the way that the police officers handled the evidence and transferred it through their chain of custody, presented many different areas for the defense to attack the credibility and the veracity of the information and the evidence that they're providing. So that the police definitely want to be very particular about what they do, because for them to survive any challenges by the defense.
And in this case, we've seen that there's been a lot of issues with respect to the crime scene or the alleged crime scene. You know, we had the family members cleaning up after the family had gone missing before the police were able to get in. There was that issue with the blood spatter on the table that was not initially noted by the police. We've seen in other cases here at Law&Crime where things like this have given just enough reasonable doubt to allow for the defense to be victorious in these types of trials. Do you think that this is going to be a big hurdle for the prosecution to overcome here?
I think it's going to be a very big hurdle, and that's why the prosecution is going so hard on to try to establish the financial motive in this case. They don't have anything that really places Mr. Merritt at the scene of the crime. They don't have any forensic evidence that ties him in at this point. And all of the forensic evidence that they do have could possibly support the defense's theory that another person or multiple people were involved other than Mr. Merritt. So there are numerous holes in the prosecution's case right now, and we'll be interested to see how they tie it all together in the end.
Yeah, it's an interesting case. So many times here at Law&Crime, we all sort of feel as though the prosecution has made its case pretty easily. And yet here, there's really some question as to whether or not, A, they've met their burden, and B, whether they have the right guy. You know, and I think that the testimony of the various detectives in this case is certainly something that is going to be important for the jury to weigh their credibility, their likability, the veracity of their testimony in order to determine whether or not the prosecution has met their burden with respect to the evidence. When you've got so many detectives testifying on similar issues, Eric, is there a certain way that you prepare for cross-examination with those? Do you try to look for little inconsistencies from detective to detective? Is that one of the things that you find to be useful?
Well, one thing that you definitely want to do when they have all of these detectives is, one, you want to pretty much establish that they're just being cumulative of one another. So you get them to basically say that, yes, this is the same thing that another officer said, because you want to show that they're basically all saying the same thing and they're not providing any new facets for the jury to consider. And another thing that you want to also make sure that they admit is the fact that none of them were there. So everything that they're saying is speculation or a guess, what they believe may have happened and may not be fact, because none of them were present when this crime was committed.
Yeah, I absolutely agree with you. I think that the cumulative nature of it, especially in such a long trial, is something that the defense can certainly use to its benefit. We're going to take you back, ladies and gentlemen, to some more testimony from Detective Steer, and we'll be back to discuss.
Number 48 and 83. Do you recognize those two photographs?
Yes, I do.
How are you familiar with those?
These are photographs that reviewed again from the San Diego Sheriff's Department. They served a search warrant at the mid-state residence in Fall River.
And why did you single out exhibits 48 and 83 in your evaluation of the case at that time?
There's presence of paint cans in 48 on the bottom right corner, along with some painting supplies above it. And in 83, in the garage, there's a couple paint cans depicted on the right side.
And what is that on top of the box to the left in 83?
Additional paint supplies.
Okay. And to your knowledge, was there also another paint can documented in the house somewhere?
Yes, I believe the laundry room.
Okay. Based on that, looking at exhibits number 250 and 348, I believe, if I read that right and correct, do you recognize those two items?
Yes, I do.
And how are you familiar with them?
There were photographs of Summer Mid-Stage Brazier found in the grave site and the Stanley sledgehammer found in the grave site.
And how was that significant to you in evaluating this case in the beginning?
Both items had what appeared to be the paint smudge on them. The bra had what appeared to be paint going horizontally across it, and then there was a paint smudge on the handle of the Stanley sledgehammer. And those are consistent with the painting at the residence in Fall River.
Objection, foundation.
Are you aware whether the hammer and the bra, what appeared to be paint, was sampled and sent off for further testing? With 52, are you familiar with that?
Yes.
How are you familiar with that?
It's a photograph I reviewed from the San Diego Sheriff's Department at the time they served a search warrant at the Fall River residence, depicting blue painter's tape around the door frame and walls to the downstairs bathroom.
And exhibit 364? I don't have it displayed yet.
364 is a clump of material that was found in the grave site where the remains were found in Victorville, which also had what appeared to be the same type of
That there appeared to be blue painter's tape.
Yes.
Our objection, foundation, and speculation.
Oh,
Showing you exhibit number 267 and 268. You recognize that?
yes. Yes, I do.
How are you familiar with them?
One is, number 267 is black backpack found in the rear side of the individual, and 268 were 3 items: a paintbrush, a spoon, and a small little paint type item that's also found in the rear side.
All right, ladies and gentlemen, so there's more testimony from Detective Joseph Steers. Eric, the detectives in this case have really had to pick apart piece by piece the evidence that was left in that home. And yet the evidence that was left in that home, there's no DNA, there's no, as you said, forensic evidence tying the defendant to the alleged murders. How does the prosecution overcome that, or can they just not do so, or do they do so by just totally stressing the motive as they're doing so far?
Well, what they're going to attempt to do with a lot of the officers that investigated a lot of the forensic evidence is to try to guide their testimony to paint the picture that the state wants to paint. The state is going to have to provide somewhere for the jury to believe when the family was killed and where the family was killed. Now, we know where the bodies wound up at, but how did they get to that point, taking everything else into consideration? So the state is going to try to use the officer's testimony about the forensic evidence to fit into whatever their final narrative is going to be.
Yeah, and the final narrative, you say whatever that final narrative is going to be. Isn't that a problem, that we don't know what that final narrative is going to be this far into the case? I understand that in each case things happen, and we used to, in my office, we used to always call it the magnifying glass of trial changes things. But shouldn't, from the beginning of the opening, shouldn't there be some sense of what the final narrative will be?
Well, I think the state has given a slight glimpse as to what their narrative would be. I believe that they tried to go forth with the proposition that the family was killed at home and then transported to the grave site. So all of the stuff at home, they're going to try to paint the picture that there was a struggle, that the family was killed at home, while the lack of forensic evidence flies in the face of that. But that might be where they're trying to go with this, to showing the items around the home, the condition of the home, to fit with the narrative that the family was killed at home and then transported to their final resting place in the desert.
Yeah, it certainly seems that that's what the prosecution is trying to do, and they seem to have an uphill climb in that. So far, and I know that we still have a long time to go with this trial, but so far with the evidence that you've seen thus far and the way that this case is going in with the prosecution's case, if you're representing Merritt, are you even considering putting him on the stand?
Oh, not at all. Not at all. Yeah, I mean, there's no need for it at this particular point.
Yeah.
I mean, if they're crafty with their cross-examination, and they can get all the officers to show that they're not there, I mean, there's no need to put them on.
Eric, I got to cut you off. We'll go to a break, but when we come back, we'll continue to discuss this very interesting case. Ladies and gentlemen, we've been watching the direct examination of Detective Steers. Now we want to take you to pieces of the cross-examination of the detective by the defense. And as they point out some of the very issues that Eric just pointed out, let's take a look.
First time she went over this, you talked to her about that occurrence.
Correct.
And she told you when she entered the house, she smelled rotten food.
Check out here, safe, beyond the scope.
You mentioned nothing of smelling fresh paint, correct?
Correct.
Then she saw different items on the counter, fruit, eggs, everything like that.
Yes, she saw different items.
And she said she saw eggs in a carton both full and broken.
Objection. Hearsay, beyond the scope.
No, Your Honor, this is actually impeachment to Mrs. Blake's testimony. She only said she saw them.
Objection, argumentative, move to strike counsel's comments.
All allow responsible impeachment.
remember the aspect of how she described the eggs were found?
Yes.
And did she not tell you that some were inside the carton and some were broken?
Yes.
And also, Blake recalled seeing a flathead screwdriver and an instrument commonly used to open paint cans in the kitchen.
Objection, relevance.
I apologize. I have to review my report to see exactly what she says.
So, ladies and gentlemen, we've been watching the direct examination and the cross-examination of Detective Steers. And Eric, as we've been discussing, you know, this is a case, and you mentioned when we were off air, this is a case that the prosecution has to do the best that they can with. Do you think that they are doing the best that they can thus far?
Well, that's hard to say given the length of the trial. I mean, like I said, a 4-week trial is a tedious journey for all parties involved. So, I think that they're going to have to do a little bit better coming with something that shows that Mr. Merritt had something to do with this more so than the financial records. I think at the end of the day, the fact that they're trying to focus in on the financial records is not going to sway a majority of the jurors or a unanimous vote, in my opinion.
What do you think about the defense's strategy to blame it on someone else, to bring in Kavanaugh into this case? Do you think that that's a smart idea, or given the prosecution's the weakness of their case, do you think that that was maybe a bad move?
No, I think it was a great move given the prosecution's weakness of the case, because that's just another factor to tip over the prosecution's case. If you can show that not only do they not have anything pointing toward this particular person, defendant being Mr. Merritt, but that there may also be the existence of another possible suspect out there, that basically shows a lack of due diligence on the state's part to fully investigate this matter and to present it to the jury without having everything intact.
Yeah, I mean, it reminds me in that respect a lot of the Aaron Hernandez case that we followed here, where there was another theory of the defense. You know, a lot of times that can be a slippery slope because you start to sort of take on the burden of having to prove that case. But in a situation like this one, where the defense has been able to show a lack of follow-up on tips with respect to Kavanaugh, that sort of underscores the entire argument that the detectives just weren't doing their job the way that they should have, don't you think?
Oh, I agree. And the fact, what helps in this particular case is maybe different from the Hernandez matter, is that we're really dealing with the financial aspect of it. So it'll be a lot easier to show that Mr. McStay and Mr. Kavanaugh also had financial difficulties in a different situation where the motive might be something else.
Yeah, I agree with you wholeheartedly, Eric. Right now, ladies and gentlemen, we want to take you to some clips of Diana Wright. She is an FBI agent who's testifying with respect to some paint that was found in different aspects of the scene and what the relation might be. So let's take a look.
Did you reach an opinion as to the level of association between items 1 and 2?
Yes, I did.
And what is that opinion?
My report reads that those items 1 and 2, could not be differentiated, and therefore they could have originated from the same source. And I gave that a level 3 association. What that means is that in all the testing that I did, I could not tell the paints apart. However, I know that there are other paints that could be manufactured that could also be present in the marketplace that could also have the same chemical components to it. So I couldn't tell these apart. I could tell them apart from other paints, but there are other paints out there also that might have the same chemical composition that also look the same physically and chemically.
But based upon all the tests that you ran, they were consistent with each other?
Yes.
Okay. Did you also, in October, receive another paint sample?
In October 2014?
Yes, I'm sorry.
Yes.
So, ladies and gentlemen, there you have Diana Wright. She is an FBI agent, and she's talking about paint that was found on Summer McStay's bra and paint that was found on the hammer, and whether or not those two types of paint could be matched. And you saw in direct examination, she couldn't say with any real certainty. And remember, in the courtroom, certainty is an important part of the jury's job to weigh the evidence and weigh the testimony. So let's look and see what she had to say on cross-examination.
You haven't actually seen the items, correct?
So when I tested them.
You saw the actual items, or you saw scrapings from it?
I saw scrapings from the items.
So this is an item that's the sledgehammer that the scrapings came from that you tested for one of the two items. And this is the bra the bra is more important to me, since you are a expert on paint. They describe the paint on the bra in the report submitted to you as a drop on the bra. Looking at 746A, would you consider that just a drop?
Objection, argumentative, calls for speculation.
You want me to say this is a drop of paint?
How would you describe that paint on the bra before you in 746A?
I would describe it as paint.
Would it be more than a drop?
Objection, argumentative.
Depending on how much was splashed onto it, it could be one drop. It's paint on the bra.
Is that, because you talked about based on your analysis of that item, that the paint went onto that item and likely cured by air.
Objection, speculation, foundation.
Overruled, she can answer if she has an opinion on that.
Did you get the question?
In your report, you talked about how the paint scraping that you analyzed, it appeared to be paint that was on that item and cured by air.
I would agree with that.
What does that mean when you put in your report that it cured by air?
What I mean is that I believe that this paint was wet when it was dropped onto the bra, and then it dried.
Welcome back to Law and Crime Network, ladies and gentlemen. I'm Heather Hansen, and we are back live in the courtroom in the McStay case, where we have a custodian of records from T-Mobile testifying. So this is going to be some important testimony, perhaps about text messages, perhaps about the pings of the cell phone. So let's go straight back into that courtroom and listen up.
How does T-Mobile, so if you have a T-Mobile cell phone, you have a T-Mobile account, how does T-Mobile keep track of the activity on that phone?
Oh, yes, sir, we do. We monitor the activity through the actual processing of the phone.
Okay. And so if you place a call from T-Mobile's cell phone, does T-Mobile maintain records of that call?
Yes, sir, we do. We maintain records. They're generated, added at the time they presumably possible that the call is made or received.
Okay. And all of those calls are maintained and collected and kept by T-Mobile during the ordinary course of business?
Yes, sir.
Okay. You said they were made at or near the time, so if you place a call on T-Mobile at right now, whatever time it is, 3:04, T-Mobile's records will show 3:04?
Yes, sir.
Okay. And is that similar with regard to any text messages sent? It will report the time of the text message?
Yes, it will.
Okay. And how about internet access?
Same principles, overall, same process.
I'm going to show you what's been marked as Exhibit 793. Appears to be a 50-page document. Ask if you recognize what that is.
All right, ladies and gentlemen, this is that testimony that both the viewer and the juror sort of starts to get a little bit sleepy about. You've got a custodian of records for T-Mobile. His testimony may get really interesting, but right now he's giving us a little bit of his background, what a cell phone is, what the records are. Eric, I want to bring you in to comment on this for just a minute. When it gets into the crux of his testimony about the cell towers and the pings and the location of the phones of the defendant and the deceased, that testimony is really important in this case, isn't it?
Well, it's going to be very important as far as Mr. Merritt, because what it's going to do, if the state is able to show that his cell phone was in the proximity of the defendant's cell phone close to the time of death, then that's going to be an issue that could possibly place him there at the scene, or somewhat near the scene, and then that's something that his defense attorney is going to have to explain.
Well, and speaking of the defense attorney, the defense has really stressed that they wanted to have their expert in the courtroom for this witness's testimony. How important do you think that that is for the opposing witness? The witness is going to try to counter this testimony, to be there and hear it live.
Well, the issue is, based on the rule of sequestration, if their witness is going to testify, he most likely wouldn't be able to be in the courtroom anyway. If this dude is providing information, if this representative from T-Mobile is providing information that is scientific in nature, then they would have had to provide that to the defense for analysis by their expert prior to trial. So his presence in the courtroom most likely would not be allowed based on the rules of evidence and the rule of sequestration, but he would have had the ability to review his findings prior to the case going to court.
Yeah, and it's going to be interesting to see exactly how they counter one another when you've got it's battle of the experts, the expert for the prosecution, the expert for the defense. I think we're going back to the courtroom for just a second. I'm sorry, we're going to take you to a break, and then we'll be back to the courtroom for just a second, so stay tuned. All right, ladies and gentlemen, so they're continuing to go through these records, and it's interesting. They've got a separate signification for text messages versus internet versus phone calls. And Eric, this testimony is actually quite vital, as you've pointed out, not just for the pings, but also for the timing of the text messages between the defendant and the deceased. Do you think that this witness might be one of the major witnesses of the case?
Very much so. I mean, he's one of the only people who possibly have any evidence that could point and put a picture where Mr. Merritt is somewhere close to the deceased in this case. However, the difficulty that the state is going to have is the fact that the remains in this case were found almost 4 years later, so they don't know exactly when he died, where he died, or anything else. So wherever his phone was at the last point that there was any activity on the deceased phone, that has nothing to do, and they have nothing to tie that into the location of the actual murder where it took place. I mean, they're going to try to say that it's close by, but that still doesn't definitively put Mr. Merritt right there as the perpetrator of the crime.
I agree with you completely, and I also anticipate that the defense is going to bring up some of the science that shows that these pings aren't always reliable, and that may be where their expert's going to focus. Is it been your experience that these pings from the cell phone towers aren't always all that they're cracked up to be?
Well, yes, that definitely is something that you have to take into consideration, especially when you're in an urban area. It may not be as important out here in the desert where they are because you don't have that many towers. The issue that you have with these cell phone pings is you don't know exactly which tower it's pinging off of when the towers are somewhat close together. But however, here you have a pretty remote area, so it's likely that there's only a few cell phone towers over a wide range of area. So the ping off that will help the state identify the actual area a little bit better than if it was in the city.
All right, ladies and gentlemen, we're going to take a quick break, and when we come back, we'll continue to watch this very important witness. All right, ladies and gentlemen, so they're continuing to go through the cell phone records with this employee of T-Mobile. He is the custodian of records for T-Mobile. And Eric, I want to bring you back in because I think it's interesting as we watch this examination, it's hard not to wonder whether or not the attorneys are surprised at some of what they're seeing. They shouldn't be surprised, right? All of this is exchanged and studied and analyzed over the course of discovery before trial.
Yes, I mean, they should have had these records long time before that, and nothing that they've given you pretty much outside of the one with the detailed cell phone tower location is information that can be perused from your normal cell phone bill yourself. So the fact that they seem so impressed or unaware with the technology of this type of data that they're receiving is somewhat funny.
Yeah, it may be that they're just sort of acting that way because they think that the jury might be, and clearly they knew a little bit that the T-Mobile guy didn't know. Do you think sometimes lawyers tend to put on a sort of an act for the jury in examinations, especially ones that are as dry as this one?
Well, I mean, the whole trial is a stage itself. From the moment that you walk in, you're putting on a show for the jury. From your demeanor, the confidence in your evidence, the presentation of your evidence, everything is a show. So I'm sure that this is all calculated. Each lawyer has their own individual particular style in the way that you relate to the jury, and hopefully that works for you.
Yeah, it's so funny that you say that because one of the lawyers that I learned from on the other side used to put on a whole thing about trial as theater. And it really is a form of theater when you're preparing for trial and when you're preparing for your opening. But even every examination and every question, it's not just what you say, but the tone that you say it. And here, perhaps that tone of surprise is meant to sort of keep the jury interested in some pretty dry testimony.
Yeah, definitely. Two things that lawyers look into is the concept of primacy and recency. You want to hit your witness with a bang at the beginning, bury all the bad stuff in the middle and close with a bang on any examination of a witness.
Yeah, that's a big psychological thing that I learned about when I majored in psychology, and it has happened again and again. It's why we open and close with such strength and vigor. Ladies and gentlemen, we're going to take a quick break. When we come back, we'll continue watching this compelling testimony in the McStay case. All right, ladies and gentlemen, so that was the end of that witness. We'll wait to see who or whether the prosecution calls another witness this afternoon over there in California, where they are a little bit behind us in time. Eric, I want to bring you back in. Everybody was very jolly about the cell phone witness. Do you think that in a case like this, where it's so dark and so tragic, where the entire family has been murdered, that those light moments in a trial are sort of good for everybody?
Oh, definitely. They help break the monotony. They get the jury back engaged. They allow them a moment to recharge their batteries and kind of, take their mind off things. So definitely, every now and then, you want to put something in there to get the jury to laugh, to think, to pause, to get some reaction out of them, to make sure that they're engaged. And the funnier you are and the better reactions you can get, you can gauge to how they're feeling you as the attorney as well.
Yeah, and that's a very good point, because as you said earlier, the fact that it's trial is theater and you're always on stage, one of the ways to engage with jurors, even though you can't talk to them directly during those asides, you can make eye contact, you can laugh with them, and those types of moments are invaluable, aren't they?
Oh, very much so. Another tactic that lawyers use is you can weave some of their personal experiences from voir dire in your questions and the way that you present some things as well.
I agree with you wholeheartedly, and I think that's a very important point. Okay, ladies and gentlemen, we're going to take you back to the courtroom because we have yet another witness on the stand. All right, ladies and gentlemen, so we're going to wrap up on this testimony in the McStay case. The trial continues, and they continue to pick apart these cell phone records. Eric, I want to bring you in for one last time. Now we had the T-Mobile gentleman there on the stand. Now we have an AT&T gentleman there on the stand. Do you think that a lot of this testimony is just going over the jury's head at this point?
Yeah, I mean, it's getting a little too technical. I think that they need to hone in on the issues that they're trying to establish. I mean, I haven't heard anything as far as trying to isolate and pinpoint Mr. Merritt as being in this location. I mean, so without that, I mean, the jury's just hearing a lot of technical numbers.
Right. They haven't done a whole lot to sort of put it in context with respect to, you haven't heard any names. Do you think that that would have been helpful to the jury?
I think that would have been very helpful. The only name I heard was Kavanaugh. So, I mean, I'm sure that was from the defense, but, I mean, I think that the jury needs a little bit more meat. I mean, the state is walking around with a skeleton. They got to flesh it out. Absolutely.
Eric, I want to thank you so much. You've been a fabulous guest, really helpful in picking apart these things, and I hope we'll see you back here again real soon.
Thank you for having me. You have a wonderful day.
You too. Now, ladies and gentlemen, you do not want to go anywhere because we have Brian Ross Investigates coming up right now. This is with an inside look at the El Chapo trial, the murders, the bribes, the mistress. High drama over 10 weeks of testimony. Closing arguments were today, and the jury is going to begin deliberations next week. Brian's going to be joined by Alan Foyer of the New York Times and a renowned sketch artist. You do not want to go anywhere.